today. We have a pleasure and really rare opportunity to learn about the choices in regulating digital markets. Often these choices are hard or even tragic choices, and who knows this situation better than Rupprecht Podszun, who actually deals with these issues for quite a long time, and in various capacities. He discussed these issues from purely academic point of view, but he also has clear understanding from the perspective of policy making. He observes and comments on these issues in this respect as well. So Rupprecht will present this vibrant and really important topic to us today, and then we will have time for questions and answers. Rupprecht, thank you very much for your availability. We look forward to learning from you.
Thank you so much, Oles, also for the invitation. It's great to see so many familiar names and even two familiar faces on screen. Hi, Magali, you get an extra hi from me since I see you. And of course, to all others as well. Now that we are such a sort of close group of many people whom I've met before and who are also very deeply in that debate, I can only encourage you to sort of jump in and take up sort of the little leads that I try to give. I thought it's at the present point of time, it's so incredibly difficult to talk about the Digital Markets Act and regulating big tech, because everything's like evolving, and things that I've thought of last week may turn out to be different now that we see one proposal after the other coming out, and sort of moving into the trilogue negotiations. So I thought I go into very fundamental questions again, and what better place is that than the place where Oles Andriychuk is working, for asking or for going into the fundamentals, even though I know that I will not sort of reach the level of fundamentalism that Oles usually aspires to. So let me share with you just quickly some slides. Hope you see them now. I just wanted to remind me, and I keep saying this to me myself to make it clear to me, what are the digital gatekeeper companies, the mamas or whatever we should call them now that they're changing names. What are the digital gatekeeper companies really all about? And I wondered that about this question, starting from the point of what is it? How do markets work? How do people take decisions in markets? What's the economy all about? This is sort of, I think we are thrown back to the very essential question of how do markets work? What should markets do? What is the role of markets for the economy, etc. And as you all know, we sort of have scarce resources. These resources have to be distributed in a certain way. And what we see here, I'm told by the internet that this is Glasgow. I've never been there, but I trust the net that you see a Glasgow slide here. And if you think of people walking the high street in Glasgow, taking decisions on what they buy, this is essentially how markets work. So some people do offers, others inform themselves about these offers and make their choices. And that is our very traditional picture of how the economy works. And this is how we distribute scarce resources in society. Now, what is the big difference that we see? And sorry for starting with this very going back to the very fundamental questions and roots. What do digital gatekeepers do? They are platforms and they work with data. This is essentially what they are doing. Platforms means they are intermediaries. They act as intermediaries to certain market sites. They use data for that, and that means they are really information brokers. They work on a meta level, so they do not give you the good that you are asking for. They are not selling you the pens, they are not selling you the cars, they are not selling you your vegetables. They are providing the infrastructure for providing goods and services. I think we cannot emphasize this enough, because that is what I would call ancillary service that they are performing. And they're performing the service with zero marginal costs, or at least very low marginal costs. They are able to externalize the risks of really providing the services and goods that you're striving for. And obviously, they have the great power of integrating markets, of integrating different services, because they digitize our full economy. And if you digitize things, that means you can bring them together because they're speaking the same language. So if you want to compare, or if you want to remember what they're doing, I think that's important to see. They are the providers of the economic infrastructure. They're not the providers of goods and services. And this always reminds me of selling shovels in the gold rush. You know that these people selling the shovels were the ones making all the profits, while the gold diggers not necessarily so. What is their sort of competitive concept? They squeeze into the operations of what I would call service providers under traditional undertakings and customers. And so usually, or in many cases, those service providers, the providers of the goods and services, lose the direct interface with the customer. And the platforms, the information brokers, are able to steer the flow of information. And that is their whole concept. And by reducing transaction costs for both sides in an enormous way, what they achieve is an enormous power in markets. They are the ones in the end sitting at this very, very influential point. Oles has written on, I think, Chilean competition that I found that very interesting what you wrote. I just picked one quote from that saying, where you said, this is unchangeable, not necessarily exactly this what is on the slide, but the power of big tech to turn everything into gold. You call it the King Midas touch that they have. And this is precisely sort of what the mechanism behind this. If they squeeze into that customer and consumer interface, in that consumer undertaking interface, if they are the ones taking your decisions or informing your decisions, then they are the ones that guide the infrastructure, that set the rules. And that's why I put up that first slide with the Glasgow shopping markets, because in that case, in our traditional idea of competition, the customers are the one informing themselves. They are walking the high street. They are doing the window shopping. They are looking at the prices. They are testing the quality of products. And then they take their choice. And this is our picture with informed choices, etc., how we imagine an economy to run. Now, this is completely corrupted, or say manipulated or changed by the way we get our information in the digital economy. And that is something that fascinates me, that we are not just seeing new companies venturing into new territory, but we are seeing a complete change of the patterns how our economy works. If I tell my students an economy works by autonomous beings taking their autonomous business decisions, this is no longer true. People are no longer well informed. People are no longer taking the decisions they wish to take on their own. They are following the leads that they get from a central service provider, from a central infrastructure provider. And that is the big change. And probably Oles is right that we will not be able to change this, to go back in time and sort of get away with that. We will not be able to do without a search engine. We will not be able to do without a very strong retailer. We will not live without our digital service, digital messaging providers. But we should be aware that this is a change of an economic pattern that we have been accustomed with. If I put that into economic schools of economic thought, I think that what we see here is the change from the more Hayekian discovery procedure, the spontaneous order that evolved from decisions in markets, in a decentralized market economy where individuals take decisions, and thereby sort of find out what's going on, find out what they want, and cater to their needs. And on the other hand, we have the more market design, and we move into the direction of a market design. Erwin Roth is probably a good proponent for that. And market design in the sense that there is a centrally planned way of how goods and services are distributed. I mean, Google knows better than you yourself what goods you should have and how much you should pay for that. And taking this decision for you is something which is very close to, in my view, central planning, right? Now it's not like a socialist party committee that tells you what car you have to drive, but it's a private company that tells you and that steers your thoughts, your needs, your wants, your information into. Sorry, I just skipped my glass here. Steers you into that direction. So we are taken care of and largely controlled, and that's a significant shift, and a significant shift that is also in economic theory, the shift to market design, because we now can work with information, with data in a much better way than before. So I think that this is sort of the fundamental thing that is changing. Now, if we want to go after that, if we want to discuss this, I think we need to answer the question, what are the principles that guide us? And now, at this point of time, where we already see the draft DMA taking the forms of maybe the Digital Markets Act that we see, I think it's important for us to reflect on the debate, maybe not so much for putting this into action or giving political advice, as many of us have done, but for reflecting for ourselves where this is heading. And obviously, I think that the idea of the principles of the DMA is completely under-researched and is completely undervalued in the debate. We have not a very good knowledge of what the DMA is about to achieve. We know that it is about contestability. We know that it is about fairness, but both these terms are well, fairness is a very vague term anyway. Contestability is something like competition, but stops short of it in the way that we sort of wish to avoid coming into problems with competencies or something. But still, I think that as lawyers and as academics in this field, we need to establish the principles that guide the DMA and need to have a more thorough understanding of what we're doing here. It's about the interpretation of rules. It's about the updating of obligations in future times. It's about coherence in the law. And obviously, it's also about our societal understanding of what we wish to achieve with regulating big tech. Now, where do principles come from? I mean, I can, of course, tell you, yes, I want this or that. But from an academic legal perspective, I ask myself, where do I actually take that from? What is my source of influence for coming up with principles? And when I thought about this question, I found that's not really easy to answer if I do not go into the political field, but try to stay in the legal field. And there are maybe three sort of influences that I would see as guiding us for taking principles. The first is superior rules. So the EU treaties, the Charter of Fundamental Rights. The second is the inner rationale of a legal field, such as commercial law or economic law. So that's what we would call a doctrinal theory or the systemic view of it or something like that. And then we may have specific goals of regulation. For instance, in the field of energy regulation, that is the provision of safe and clean energy as a goal that we try to achieve. Now, that is sort of the general mindset that I try to apply when thinking about what do we want with the DMA. Where do we get this from? And I find it particularly interesting that we in the past years started to think from the perspective of fundamental rights or other provisions in the treaties. Think of the sustainability debate, where we have that in a very strong way, where we follow pathways into competition law that are differing from other things. And also in that very inspiring German Federal Supreme Court decision on Facebook, you definitely have heard of that. The German Federal Supreme Court says the competition issue in the Facebook case is heavily influenced by fundamental rights, namely by persons' individual right of control of their own data. So privacy, or maybe even better, I read the decision more as being about consumer choice, about control of what you give out and whatnot. And if we leave this path and if we do not take that into account, maybe we even end up in a situation where some of these very fundamental rights and principles that we see as so important in our national jurisdictions, that we see so important in in what we are doing, in being lawyers, thinking from the superior rule to the lower rule, I think that we need to take that into account. And that's maybe even a bit unexplored in the DMA, whether the DMA has anything to do with fundamental rights or other core principles of EU law. Now, the other field that I wish to marry with this idea is the idea of what is economic law about? And in my very classic understanding, it's about avoiding or correcting market failures so that the economy works smoothly. So put differently, making markets work. Now here, we enter back sort of to this slide where we have to answer the question, what makes an economy work? Is it the individual decisions of individual people in the more Hayekian idea of spontaneous market order? Or is it something that can be centrally planned by undertakings? And if we lean to that one side or the other side, that may heavily influence the principles that we wish to see in the DMA. So if I'm happy with the market design idea of digital markets, and if I say we cannot turn this back anyway, let's do Google all the work, let Google do the work for me in my economic behavior, let me be guided by Amazon, fair enough. Then that is sort of your way of making markets work. And to be frank, I have not yet found the key of putting these two together in a sense that keeps the Hayekian idea vivid, and I'm happy to hear what Oles has to say on this, saying we cannot change that anyway. If I take a look at all this from the at market failures, I just wanted to point out very quickly, because this is something that interests me personally, that I see very many market failures in the digital markets that we have, and I see a lot of principles and a lot of ideas also in the Digital Markets Act. So high concentration markets, monopoly power, market power is a traditional, typical problem of markets that are influenced by GAFA companies. Negative external effects, information asymmetries, principal agent conflicts, the reduction of user choice. All these are problems that we heavily see in these markets. We have principles for that from institutional economics, from our ideas of market failures, of remedying market failures, principles like contestability, the polluters pay principle, the principle of reliable information, or the remedying of asymmetries, the principle of fair intermediation and control of agents that are otherwise not controlled by the principles, or the principle of user sovereignty. And that then means we need to sort of do the obligations in a certain way. And I would wish for us as the legal community of legal scholars to interpret the DMA once we have the obligations ready with a view to these principles, with a view to, I mean, as this forming the doctrine, the systematic idea of the DMA. Whether the parliament, the governments and the commission are giving us something where we can easily do that, that's a different matter. I don't know. Maybe they give us a complete mishmash of whatever, but then it's our job, and we should try to work with these principles to identify what's going on, because we need these principles for further obligations, for updating the obligations, for interpreting the rules, etc. So that's my proposal, sort of what we have to focus on once we see these obligations in practice. I do think that we have these specific problems with digital gatekeepers. Yes, they do systematically profit from producing and exploiting market failures, and their genius tactics is to let others do the work, provide the service, get that person into the hotel and provide a bed for them, while they just sort of do the data stuff around it and the business stuff around it. And that's a brilliant way to externalize risks and still profit heavily from it. Well, that's the results of that. They earn a lot. Now, I wanted to briefly go into, for the final minutes, briefly go into some of the issues that are currently on the table in the final discussions of the DMA, and just sort of give it a glance and give some thoughts to that from a perspective of principled rulemaking, and maybe also try to discuss what the framing of these decisions is. I think that the absolute number one question that is currently on the table is the question of who will be designed as a gatekeeper. What are gatekeepers? And this question obviously is so important because if you're in or out, that makes all the difference. Whether it's 5 companies or 10 companies would be a huge difference in application of the DMA. And this is also a question that has been so heavily lobbied on, obviously, by the companies, because I mean, the GAFA companies do not need to concentrate on this because they are in any way, but all others, say Booking.com, Airbnb, Zalando, Spotify, etc., eBay, they could be in, and whether they are or not makes a huge difference for their business models and for their businesses. So they are lobbying this question so heavily. And so the question that we should ask is, what makes a gatekeeper? Is it really, is GAFA, are the GAFA companies anything different from, say, Booking.com, just to take Booking as an example, because they are always sort of one of the ones mentioned in the debate. But what we usually do not look at this from analyzing business models, at least that is my feeling, but we look at this from other perspectives, from the efficiency of the whole system. Is it easier to enforce if we have 5 companies, or is it easier to, or does it work with 15 companies as well? Can we be a bit more severe with the obligations if we have less companies that we look at? Are we ready to regulate EU-based companies? I think this is very difficult for many governments. They wish to protect some of their homegrown digital startups, or former startups, to be frank. And do we sort of down-regulate potential competitors of GAFAs? That is the way these questions are often framed, while the question that we honestly need to answer is, what makes a hotel booking portal different from a general search engine or a big retailer? Is it just the market share, or is it that they provide another service? In my view, many of the problems that we have are related to the general working mechanism of these companies, which is they are platforms that work with data, and I do not necessarily see huge discrepancies between different platforms. Second issue, are we really ready to tell consumers that some things that they love will go away? So consumers love all these companies. I think we in our elitist bubble here should be very well aware that most people love Amazon, and it's just these competition people that have a problem with that. People do not like consent, cookie consent settings. They do not like necessarily like to take choices, etc. So are we able to tell these people, you have to change your behavior? And are we ready to enforce that? And are we ready to maybe tell them, okay, some of the services that you would love to have in a pack will no longer come in a pack because this kind of bundling is something that we do not wish to see. So are we ready to make life more uncomfortable for consumers? Having said that, is that the right question to frame that? Or is that some ideological view? Do we need to leave the freedom to consumers to do that? Or is that a consumer welfare issue even? I'm very unsure about this, but I want to see how the EU Commission, in enforcing the provisions once they are enacted, starts telling people, okay, this no longer works because we have the DMA we have the DMA now, and now you're forced to separate this unit and that unit, and consumers may no longer have this combined service. I don't know whether we are strong enough to walk through that, and whether the Commission is strong enough to walk through that. And if so, what is the line of defense? What is the argument in favor of or against it? If we put that question on the table, open question. Interoperability obligations. I've seen Simonetta in the room. She's the one to talk about this. Does interoperability stifle innovation incentives? I somehow cannot imagine that the DMA and will lead to Google, Amazon, Facebook, Apple, and other companies no longer being innovative, no longer being successful. Maybe they adjust their business models here and there, but will they really will that really be the big change? I mean, has Microsoft changed large scale after opening up certain APIs after that first decision, or is it still one of the most successful companies in the world? So I think if we are confronted with this so-called innovation argument, we risk barring innovation. This is often framed as a under-enforcement versus over-enforcement thing. And then we obviously run into the problem of being lawyers, having to tell people, oh, it's much better if we take a rather cautious approach. We should not over-regulate, we should not over-enforce, because this may stifle innovation, this may be bad for companies. The truth is probably we do not really know what happens, and probably particularly interoperability, I think that is a key issue, but you can do that with all other examples as well. Interoperability and other examples may lead to very good results, to much better innovation, to much better outcomes, to much better choice. But we don't know. We are uncertain in this regard. And the question, in my view, is not so much under enforcement or over enforcement, but the how do we deal with uncertainty? What is our normative approach to this field where we do not exactly know what will happen once we enacted these rules? So if we go on this sort of route of saying this is a type 1 or a type 2 or error or something like that, I think that we are already very much in the logics of a laissez-faire approach, and where as lawyers we have very huge difficulties to counter-argue that, while the other side does not know any better than we do. It's so I think we should not sort of be on that slippery scale. Another thing in this regard is the self-executing rules. You know that there is hard lobbying against self-executing rules, and people say that we need more regulatory dialogue, we need to be able to put forward our arguments in favor, etc., and we need to specify with the Commission. This sounds very plausible if you listen to it. The per se obligations that are automatically effective will probably not work that well in practice. That's what they always say. The business models are so different, etc., etc. If you have self-preferencing, no one knows what this exactly is, etc. Is that really a problem for enforcement, for the validity of these rules, for the execution of these rules, or is it just a shift of risks in procedure? I think that for me, I'm doing a lot of unfair competition law as well, not just sort of classic antitrust rules. And in unfair competition law, we have thousands of such rules, or at least some of these rules, as in all other fields of the law. I think it's a very competition law specific thing to think of, to think that there always has to be a contact with an authority that can tell you what you have to do or what you do not have to do. I wonder whether we are again framed in a way here, or that the problem is again framed in a way that is completely contrary to our idea of the law. If we come from a normative perspective and say this is something we do not want, it is the obligation of the undertaking or the norm addressee concerned to adhere to the rules. And if they do not do that, we go against that, period. And that's sort of the typical mechanism how laws work. While in antitrust law, we are with incoming economists, with very strong authorities that are discussing with companies, we have maybe a bit different mindset. But since the DMA is not really competition law, as some people say, why not sort of turn to the typical way of saying you should not do that? And if that's prohibited, take care of not violating the rule. And if you do, we step in and enforce. So again, the whole debate on self-executing rules, in my view, is framed in a way that puts us into a legal logic that is very difficult to escape from. But in reality, in other fields of the law, it is very typical that we have such self-executing rules. The same is true for the efficiency defense. This is not a competition law act, in my view. In competition law, yes, we work with efficiencies, but in other fields of the law, we don't. we do not necessarily need to take care of efficiencies if we have the normative conviction that this is the right thing that we want to see. If we think that interoperability is something that we wish to see from a normative perspective, we do not need to care about the economic problems coming from that. If we did that, we could scrap a lot of our rules in other rule books as well. So I do not see the efficiency defense as a problem of justice. I see the debate about it more as a problem of justice. Finally, speedy proceedings. This is something where I'm also grappling with the issue. We try to speed up proceedings. In Germany, we saw a rule on digital gatekeepers where we reduced the scope of judicial review in a massive way. I'm not sure that this is something that we as legal academics should subscribe to. I'm still sort of, I still think that even the GAFA companies have the privileges of the rule of law and should be able to have the rights of defense. Here maybe sort of, while much of what I've said is maybe more in favor of strict application of rules, I fear that sometimes the commission, the governments and others that are on the enforcing side downplay the very core legal standards that we go to. I skipped maybe these final 2 points for the sake of time. Just one final remark that I wish to make is that reflecting on the debate, being again on a bit on the meta level, I find it very interesting to see how different actors engage in this debate. Academics like us, the lobbyists for GAFAs, other lobbyists, parliamentarians, governments, obviously the commission. And it strikes me that we have not led that debate that Margrethe Vestager tried to start in 2018, I think, with her, when she started with this agenda. I think that the debate she promised us with the report of the special advisors, that we have not really led it, but that most actors have stayed very closely to what is near and dear to their hearts. And that's something that's missing. I mean, if you look at what the governments are currently doing in the council, what we hear is mainly they are taking care of the question of our national authorities, included or not. They're not asking the question, or at least we do not hear about that, whether interoperability is an important rule. Parliamentarians are sort of the individuals that have their very individual concerns with their pet projects. And academics also have their pet projects. I mean, I certainly do. And obviously, they have their influences as well. One of my team members, Philip Bongatz, who's very much into this debate, just told me the other day, if you look at the papers written by academics on gatekeeper status, all papers that came out in the beginning of the debate were heavily sponsored by certain companies, and they paved the way into the academic debate on gatekeeper status, and it now plays out because we are moving, or there are very strong voices moving to the situation that we should only regulate GAFAs. I haven't really looked at the issue that closely as Philip has, so I'm not sure he's 100% right that all of us were bought and put forward certain opinions. But obviously, I mean, I know that those of you who are members of ASCOLA who are in this debate adhere to the code of ethics. But I would wish for a system where we even in the footnotes say the paper that I cite here was sponsored by XYZ, even if it was written by a professor. The final slide is obviously John Sherman, and just reminding us these are political questions. We are now in a field where we no longer look at economics only, as Sherman has with the Sherman Act. He did not only look at economics, he had a political interest, a democratic interest in that. That's something I wish for. And now taking the debate forward, I wish for us as legal academics, pushing that debate to maybe our time is gone sort of for the negotiations now. We cannot influence that so heavily. But once we have the DMA, I think that our role is to interpret it in a way that makes sense, taking the legal principles, the superior legal principles that I tried to sketch, the principles from our doctrine, from systematic views of how the economy works and should work, to this debate, and therefore make the application of the DMA, once it is there, more coherent and into the direction that sort of I wish to see in fulfilling these ambitions that we have with the whole thing. Thank you so much.
Thank you very much, Rupprecht. That was really thought-provoking piece, and nobody is surprised that you shape and articulate such vibrant ideas. Let me open the floor for Q&A, and Magali has already a question.
So I've got a lot of questions. This is the problem when I listen to these things, I suddenly have loads of questions and I write them down and then I have another question. I'll start by saying that I think I subscribe to the desire for more coherence, especially because in the DMA, there are provisions that say that the effectiveness of a measure adopted by a company will be evaluated based on what the objective of the obligation is. And it seems to me that it's not clear what those objectives of the obligations are. So that's a flaw in the DMA that we should rectify. So I think you're right, Rupprecht, that we need those answers, not just for our own intellectual sake, but just for the implementation of the DMA. In the last few weeks, I've been trying to write a paper and failing miserably on the opposite of it. I think we need coherence in the DMA. I also think this is an opportunity to make competition law more coherent, because if we pull out a lot of the strands that are now in the DMA and other pieces of regulation, it gives us a chance to be more specific about what competition law is supposed to achieve. And I think this comes from, I teach US and EU competition law, and I struggle to teach my students, the differences and the similarities between US and EU. But I've come to terms with the idea that I'll lie to my students and I will tell them competition law is only supposed to intervene when a market has most of what it needs to be competitive, but a firm's conduct impedes it, and you could intervene surgically, fix the problem, and make the market work again. I lie to the students because that's not what we do in the EU, but it makes it easier for them to actually take everything they learn about US and EU and pull it on that. My question is, should I maybe stop lying and should we make that a reality? The current problem, I think, also with the gatekeeper, and that we don't know what a gatekeeper is that we're not talking about market power, we're talking about economic democracy, we're talking about power over other actors that doesn't fit in our normal systems. So I guess basically what I'm asking you is, do you think that in addition to making the DMA more coherent, which we should definitely do, it's maybe time for us as computational academics to come in and be more clear about what we are doing, narrow the scope of competition law so that we make more room for other types of regulation to come in and do the things that we might not be equipped to do. And then a small comment on your thing about the first academics coming in and writing, the ones being paid for by these companies. I think that's partially true. But also maybe as academics, when we want to do a well-reasoned reflection on something, it takes too long. We're like the courts. We are too slow to actually respond in a good way, but we need those good responses to make it work, but we're actually too slow for the demand. So yeah, I want to write a paper. I've been thinking about it for a year. By the time the DMA is passed, I might possibly have an idea of what I'm going to say. It will be too late. Whereas if you're paid by Google, it's easier to produce something quickly, right? So anyway, that was a lot. Sorry, Rupprecht.
Well, thank you. On the slowness of academics, I think you're right. And that makes it so, I mean, we need the time. That's obviously something in the sense of if we really want to give good judgment, that means we need to take that time, and otherwise we cannot say anything on that. On the other hand, well, we cannot wait for another year before we have discussed all that. So, yeah, very difficult point. But I fully see that. Now, regarding the competition law issues that you put up, I'm not so sure. I mean, I found that very interesting, that the metaphor of you like surgical interventions that work. On the other hand, or maybe I don't get the point now, but I always thought competition law is not like correcting markets large scale anyway. It's more about finding out what's going on and then sort of having this one or two landmark cases that do not change the world, but that gives us an idea of what we could do in other fields or so. And maybe you can tell me a bit more what you have in mind when you say we need to narrow the scope of competition law, because I think the great thing about competition law is not so much that we change the economy at large, but that we are able to look at problems like, say, data, privacy issues, etc. That we can look at that in very professional, great procedures with great people with a lot of power behind that. And then in the end, we find out this is problematic, this is not problematic, and then we move it maybe to other stages, or we allow parties to do private enforcement, or they integrate that into their compliance sheets, etc. So changing it in a very sort of subtle way, rather than the big things. So maybe my idea would be more competition law is symbolic anyway. It's a metaphor for the state trying to claim some influence over the economy, and therefore we do a big case once in a while. But so we learn something about the economy. Maybe we have some deterring effects by huge fines for the obvious things, say hardcore cartels or so. And that's about it. But I'm not sure whether I got the gist of your question right. And I'm not sure I really mean it, what I just said.
Thank you very much, Magali and Rupprecht. If I may ask you also a question about making choices indeed. And probably you started with outlining potential goals of the DMA. So that's kind of the starting point of any reasonable, meaningful discussion on the DMA. What do we want from this act? And not only from purely kind of formalistic point of view, but whether it is 114 or 352 or something else, but rather kind of strategically. So I wanted to ask you your opinion, Rupprecht. If you look, and you have highlighted pros and cons of all possible scenarios: consumers, intra-platform competition, something else, something more kind of market designing or trying to boost, to encourage entries by newcomers. Which type of newcomers, we don't know again. But I wanted to ask you, if we assume that the DMA is an act and it's kind of an incarnation of the political will, which goes beyond the mechanistic calculation of welfare. I'm not being critical about consumer welfare, but overall that the belief that we can measure things and that the right answer comes from our calculation. We have to be robust. We can disagree upon the outcome of calculation, but we agree upon the metrics. So this is kind of dry law and economics vision. And it looks that we are abandoning this approach, at least in the DMA. We also abandoning it or softening it in ex post rules, but in DMA in particular. So, and thus more flexibility and more room for interpretation. And thus we need to know, or not we need to know, but there are possible conflicts, and conflicts are depathologized essentially. Conflicts are inevitable when we do difficult choices. So my question is more kind of empirical to you. Do you think there is such political will, there is a political vision about the DMA, and our task is just to discover it by observing and trying to be smart and trying to somehow project our intuition into this political will, or it's just a cacophony of different political interests, EU, national, all this kind of local interests, and ad hoc constellation of different priorities?
Well, I think it's the latter, but still our task is the other one. So, I mean, obviously all legal acts are somehow a cacophony of different interests and a regulatory sort of mishmash, etc. I mean, politicians don't look at doctrine and don't look at systematic rulemaking or so, but still I think that's our job to make the best out of it, or did I get that wrong?
And maybe then, yes, no, I see the point. And maybe then more practical question probably. We know that both EU and UK reforms of digital markets have been underpinned by this kind of idea of participatory antitrust. And thus we hear the mechanism of regulatory dialogue. And we see that in the EU, in the DMA, it has been mentioned, yeah, and in the one of the recitals. And it looks that the mechanism of regulatory dialogue will be offered within Article 6 for calibrating obligations. Whereas it looks again that in the UK model, we have a proper dialogue between SMS and DMU about what precisely do we want as an enforcer, and how do we want to put these rules in the code of conduct, which would be, enforceable and will not be intentionally vague and opaque in order to catch you if you don't comply. But we want to reach an agreement, essentially, and particularly when we're talking about a handful of companies. So do you think if this description is correct? I think we were hosting your co-author Philip Marson recently in another venue, and he somehow confirms that that's kind of his. I am paraphrasing his description. So, if this is correct, do you think that UK model fits better into this kind of idea of participatory antitrust, and EU model is still more kind of adversarial, aiming to catch the wrongdoers and to basically to put different legal traps, saying, okay, however powerful you are, we will still catch you, and then it's kind of commitment plus format, essentially.
I think that the depiction is sort of correct. That would be my understanding. I'm not an expert of the UK regime, though, but I think that's correct. But I'm coming from a jurisdiction where participatory antitrust is something that we do not know, or basically do not adhere to. I mean, if the Bundeskartellamt, the German competition agency, takes up a case, obviously they engage with the companies in the sense of they have a right to hear, etc. But they are not even trying to get a settlement in the sense of, oh, let's discuss with Google how we could do that. I mean, there are obviously some shades of that, etc. So, and maybe this upbringing of mine in the German legal context makes me very critical of that. I mean, since when do we ask the murderer whether murder should be illegal or not? I mean, that is not something. Is that really something that we need to act on with the people that we that we try to commit to certain rules? This is what I mean when I say I want a normative framework with a clear legal sort of concept and with a normative sort of power. We are not trying to regulate Google in the sense of, oh, let's try to be friendly with Google so they don't screw up or so. But we want to live in a certain world that is governed by certain principles, and then I put up the rules and then I enforce it, period. And I mean, the problem that would always be my understanding of lawmaking, while the more consensual path, the participatory path, etc., is something that I'm skeptical about because of regulatory capture, etc. So having said that, obviously the question is whether governments are still able to do that, because we all so heavily depend on these companies. And if that is the case, that would be really alarming if the Commission or the DMU in the UK would not be able to deal with these matters without engaging with Google in a way that is more than just giving them a right to hear, as I would obviously agree that that's natural. But so I'm a bit more skeptical probably than people from the UK in this regard of participatory antitrust. And I hope that we are able to put up rules and to enforce rules that we see as right, and they will be able to deal with that. I mean, maybe one final sentence on that, because we've always witnessed that in the IP, in the intellectual property debates, when essentially Google put forward the argument for YouTube, they are not able to filter the content in a meaningful way, so that they are able to keep up YouTube. I mean, no one could prove them wrong in the sense of what judge in a German first instance court should be the one to tell Google, okay, you can filter, you have all the economic power, you have all the computational power, you have all these brilliant people. And I have never been convinced of this approach, in the sense of, if they're committing wrongs, if they're putting up IP violating videos, that's still a violation of the rules. So if they are not able to filter that, then what? Then maybe they have to close down their business if they are not able to. And if they are able to, we cannot sort of, maybe we are not able to say that from the outset, but does that make it possible to violate the rules or to violate IP rights? I'm not sure. I don't want to go too much into the IP debate. I just want to, I mean, I have more sophisticated views on that as well. But I always fear that this argument, okay, we cannot do that, or this is completely impossible with our business model, etc. That's something, does that really hinder us from putting forward the rules that we wish to see? I don't know.
I think that was very helpful, because it clarifies your position and your kind of adherence to your optimism about the ability of the legal system and the legal, let's say, epistemic toolkit to not necessarily to comprehend, but at least to frame and to steer and to prohibit specific practices. And this kind of conventional excuse, which we hear, well, look, they are omnipotent, you prohibit, that's basically my argument, yeah, about King Midas, yeah, essentially. It shouldn't prevent us from designing the rules as much, which would be more sophisticated, but still precise and self-executing. Is it your kind of normative position? Right, yeah. Okay, thanks.
I mean, that's something I wondered about when I read your piece, Oles, and maybe you can sort of, if I may ask the questions now here.
Exactly. Yeah, thank you very much, Rupprecht. I think that at least we know where we are both. Yeah, my understanding or my interpretation, my reading of the DMA in terms of its enforceability is that I'm taking kind of vulgaris. We design the rules which are vague and imprecise, which cover everything, whether they are enforceable or not. If they are enforceable, well, good. It's kind of tactical achievement, step by step. If they are not, we will find a way to establish a instance of non-compliance and then systematic non-compliance. And then essentially we come to the dialogue where we say, guys, you have infringed A, B, C, D. And if we interpret this infringement broader or non-compliance, you will then infringe B, D, E, F, G, H. So depending on our understanding of what we want the market to achieve, we want you to change the practices. We want you, as your example with filtering, we want you to adjust filters, not pro forma, not by ticking the rules and still achieving your goals, but we want you really to design your filters in a way as you design to eliminate harmful content or kind of aggressive, radical content, and you are very successful in doing so. You can do it actually, and thus within this kind of regulatory dialogue, we achieve a meaningful compromise, and that's the exclusivity of the Commission. It must be one center of communication. If we disseminate the centers across national competition agencies and private parties, this would weaken the mechanism. I'm talking only about the mechanism, which I think appears to be kind of the logic underpinning this, the enforceability of the DMA. Maybe it's absolutely my just, it is purely my personal interpretation, of course. But if this is correct interpretation, then we need centralized enforcement. Then we need to fine tune not the rules, but compliance with our kind of informal agreements. And that's what I mean by regulatory dialogue and participatory antitrust. And your position is still, let us make the rules as accurate and let us design them, let it be future-proof, but we will adjust them accordingly and we will learn and we'll speed up the process. So these are two different approaches to regulating this thing, this issue, I think. Okay, I think we have approached 1 hour exactly. Let me check if we have. I leave the room for one final question. I think Simonetta, are you still with us? Because you mentioned something about your train. Simonetta, we see you, yes.
I think Magali also still had her hand up. Maybe she wished, or if Simonetta,
sorry,
of course.
Can you hear me? Yeah, okay. So sorry for, as you see, I'm in the train. Oh, yeah, so my question, I've written it in the chat as well. So I started off quite enthusiastically about the DMA, perhaps you as well, Rupprecht. And I've seen in this last year of discussions, many issues with it. And at some point, I'm starting to think that it's a distraction, the DMA, relative to the things we should be discussing now. So I think it's a way of perhaps even hampering innovation in competition policy. And I see as two examples of innovation, the provision in the German antitrust law, 19A, which I think is a type of innovation. Another one would be the provision which is currently discussed in Greece concerning ecosystems. So we had just 1 year of discussions on the DNA, the difficulties, and now whether it's going to work at all. And I think we missed important time that perhaps we should have spent discussing more the issue of digital competition. And as you were saying, Rupert, at the very beginning, what type of digital economy do we wish for? So it's a matter of markets, perhaps market design, if it were, recreating some. So I don't know, that was my impression here following the debate. So what do you think, Victor?
I don't know whether I'm the one. I think that's a good comment. I think it runs a bit along the lines that Magali talked about earlier, or Magali, maybe that's you may correct me if I'm wrong, but yeah, maybe that's a good point. I mean, I was thrilled, as you said, when the DMA came up, because I thought this is now really something where we can put in a bit more than in traditional competition law, where we had the impression this is all going too slow and it's all going too much into in sort of efficiency balancing and exercise that doesn't do any good to real concentration, or that is moving too slowly. Maybe you're right, and I particularly, I mean, you made the point that we maybe need an interoperability regulation. I'm fully with you on that. In that, maybe I think there are some initiatives on sectoral basis for such interoperability obligations, but yeah, maybe we've been distracted in that sense. Yeah.
Simonetta, do you want to respond or to react?
No, I mean, I think it's the debate worth having, because well, at the same time, I think the DMA is quite correctly leaving some room for national experimentations. So that the last wording we have seen of a country, there would be still room for national provision. I think it's very important because we still need to experiment in this area. We haven't done it enough.
Okay, we can probably talk about these things for much longer, but I assume we have all other commitments, and let us have this hunger for further discussion still with us. So Rupprecht, I hope, and all participants, I hope we'll have other chances to exchange our views on this ongoing topic, where the facts change so rapidly that it's really difficult to catch up, even if you follow it kind of regularly. It was a great pleasure to having you with us and to sharing with us your ideas and your insights. As always, it was really a pleasure. Thank you very much for your bright thoughts.
Thanks to you, and thanks to all of you for the discussion.